Yes, good evening to everybody. Welcome to the class of the Laugh Tart, and today is the fifth class which is going on over there. Then I put it something on the screen. Please, anyone can unmute and read so that I could know that you are hearing me and you could see my screen also. Yes, hurry up. Unmute and read, anyone. Hurry up.
Good evening, Law of Tort online class on Friday, the Anatomy of Tort Law. Professor Dr. Mohammed S. Hussain. Sir.
Yes, thank you very much that you read it. Now, without wasting the time, let me come to the point yesterday that we are at the. These people are coming late, so my time goes in that meeting. So, so yesterday that I dealt the Sardar Amrit Singh, Karla versus Pramod Gupta, this and others. We did it. It is nothing but the UB just UB remedium. That case is regarding the principle of fundamental principle of law. It is held by the Supreme Court. It is the duty of the court to protect the rights of the people to grant the relief to the aggrieved party rather than denying it. If anybody's right is violated over there, naturally there should be a remedy. Otherwise, there is no meaning of the right when there is no remedy. Because this asterisk mark, I kept it over here, now I remove it. Then let us see the D.K. Basu versus State of West Bengal. This is one of the landmark case law where the D.K. Basu, he was the chairman of the Legal Aid Service Committee, and this man has wrote a letter to the Chief Justice of India regarding the activities going on in the prison. So the Indian Express, the Telegraph, the Supreme Court has given the guidance that yes, if anything goes violence in the in the police custody, if anybody is suffered over there, there is nothing but a violation of the legal right. In addition to that, it is a violation of the human rights also. So, if in police custody death, the high handedness would be the by police, then the state would be held liable to pay the compensation for that regard. So, this is the where the violation of the right is there, then there should be a remedy, and hence the injury assigned and demnum was there that would be applicable. So in the remedies, we will say another, the legal remedy is the third essential of tort. The wrongful act or omission of the defendant must be an actual wrong which arises remedy is a civil action for the damages. So the essential remedy for the tort in action, but there are other remedies also available in addition to the in addition to the money as a compensation, even the injunctions also there. In sometimes the specific restitution of the property also, then an equitable remedy is available to the injured party. So the law of tort is similar to the Latin maxim ubi just ubi remedium, which means there is a right without a remedy. So no right without a remedy. That means where there is a remedy, where there is a right, there should be a remedy. So that is the thing actually it is stated. So where there is a wrong, there is a remedy. Granting right without the provision of the remedy is the case of the breach of those rights would be quite pointless. So if the right is violated, if there is no remedy, that is a pointless. They're quite pointless. Similarly, the law of torts also prescribes certain forms of the legal remedies for the injured party, such as damages, is one of the form. Specific restitution of property is another form, and the injunction is another form, are awarded by the court. Before awarding any relief to the claimant, the court examines the certain aspects of the liability by performing tests such as a test of directness is there, a test of the force severity would be there, or other in order to judge the remoteness of damages suffered. If the two remote damages are there, then the plaintiff is not going to get any compensation. Thus, the four essential elements of the law of tort has been explained in this article or in the above. Then the one is the duty, another is the wrongful act. When you say wrongful act, there is a legal injury is concerned. Then the injury, then comes the remedy together from a chain. If the chain is broken over there, then the intermediate will be liable. Now let us see some of the distinction between the torts and crime. Number one, a tort is basically a private wrong, as we said. It is the infringement of the person's right in rem. In other words, it is an infringement of the personal right. While crime is a public wrong and is against the whole world and the state, it is an infringement of a particular person. In other words, the infringement of the public right. So that is the first of the distinction. Is the tort is a private wrong and crime is a Crime is a crime
Public
is a Why you are taking so much time? Because it is here. Even by looking at also, you can give me the answer. That is a public wrong. Number two, the remedy in the case of the law of tort in the form of damages. The primary remedy in the law of tort is not the incarceration or putting behind the bar the tortfeasor. Because if you put behind the bar, that what he is going to get it? Nothing. Hence, damages are the primary remedy in the law of tort. Or in the case of the crime, it is in the terms of the punishment. That the punishment would be there. But nowadays, the jurisprudence is changed over. But in addition to the punishment, the court is awarding the damages to the victim. For instance, the rapist, the rape cases, there would be a stigma on the woman, and hence damages are awarded over there in addition to the punishment. Number three, in the case of the tort, a suit is filed. So an individual will file a suit, whereas in the case of the crime, we will give the complaint. We will give the complaint where? Sir, we will give the complaint to the post office. Yes?
Station.
We will give the police station, concerned police station. The jurisdiction which is hanging over there, the police station, there we will give it the complaint. The person who is giving the complaint is called complainant. So, number four, the law of tort is an uncodified law because there is no codified will be there. But certain aspect is codified. Can you tell me which part of it is codified in the law, tort law? Any idea? If you don't have idea, I say pass on.
Pass on, sir.
Like Workman Compensation Act is there. It is codified. And some of the tort like the Motor Vehicle Act is there. It is codified. Are you following me?
Sir.
Okay, sir. Okay, sir.
Certain forms are codified, but other form is not codified. But the law of crime is a codified or uncodified?
Codified, sir.
Codified, sir.
Example?
IPC, CRPC.
Why CRPC?
Sections.
What is the distinction between IPC and CRPC?
Crime framing.
IPC is a substantial law. CRPC is the procedure law.
Okay, sir. Okay.
Is it clear?
Okay, sir.
Say yes. Okay. So in tort, yes. Any doubt? Do you
Sir,
want to
your
come?
volume is very low, sir.
See, my volume is very high. When you record it now, you could know it. But when your mobile data is very low, that's why you could not hear it in proper manner. Because I will send it to the YouTube now. You see how much my volume is. Okay, now let us come to the point of the tort. Intention is important, but in all cases, whereas in the case of the criminal law, intention is the crux of the offense itself. So intention is important, but not in all cases. But whereas in case of the criminal intention, crux of the offense itself, because whether the intention is there or not, whether the guilty mind is there or not. Are you following me? Say yes.
Yes, sir.
Very good, very good. Sometimes you have to say, otherwise I will think that I am speaking to the wall. Are you following me? Yes.
Yes, sir.
Okay. Number six. In tort, the tortfeasor does not feel there as a stigma. Who is a tortfeasor? A person who does a tort. But he will not feel a stigma because as he pays the compensation and move with a high neck collar. But in crime, it is a stigma to the victim. Do you know what is stigma?
Yes, sir. Mudra.
ముద్ర ఈ ముద్రది లేబుల్ అయిపోతుంది. ఏం లేబుల్ అవుతుంది? దొంగనన్నా ఆర్ రేపిస్ట్ అన్నా అది లేబుల్ అయిపోతుంది అన్నట్టు. ఇన్ క్రైమ్ ఇట్ ఈస్ స్టిగ్మా టు ద విక్టిమ్ అండ్ పర్పరేటర్ అండ్ హీ విల్ పుట్ బిహైండ్ ద బార్. So a good example of this can be assault, where the party who has been assaulted can bring a charge against the person who has assaulted him or her. Also, he or she can claim the damages in civil court under the tort law. In assault or in a battery, both the cases, in generally, when a person touched it, it is a battery. When he made an apprehension of it, it is an assault. But in a battery, it is both a crime as well as a tort. For instance, motor vehicle, an accident. An accident is both a crime and a tort because tort, a police will file a complaint. and a civil wrong, a compensation, a private individual who got a victim will file a case, a suit in the court. So it will both the cases parallel. It will run. It will run in parallel. Suppose if the criminal case, if that fellow is acquitted, it doesn't mean that it will not bar to the civil action. Oh, how much you got my point? Where the case of the accident, parallel two cases will be filed. Number one, a private individual who suffered will file a private suit. Number one. Number two, the nearest jurisdiction, a complainant who gives the complaint, where the police will file the case. So two cases simultaneously will run in the court. In case the criminal case, the accused is acquitted, it doesn't bar to the civil case. I don't know how many people got my point. Did you get my point? Or it is a bouncer? It's go beyond your head. Yes?
Sir, please explain it once again, sir.
Yeah, okay. In motor vehicle cases, there are two cases will be filed in the court. Number one, the victim who got injured, he will file, or on behalf of him, somebody will file the case. It is a suit for the compensation. And in the crime, a complainant, when an accident occurs over there, giving the complaint, or the police will come and register the case, and FIR will be made. Then state will move the criminal case. Both will run parallel. In case the criminal case where the accused is acquitted, means released, does it a bar to the civil action of the compensation? That's my question. If you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
Awesome.
Yes. If a criminal case, the accused is acquitted ante free కావడం అన్నట్టు, convicted ante బాధ్యత పడడం అన్నట్టు, imprisonment. If he is acquitted, it does not bar for the civil action, because criminal law says beyond the reasonable doubt. But what the tort law says? It is preponderance on the evidence. So that is the reason. The civil case will be going on over there, then naturally, if he is negligent, definitely that he will be liable to pay the compensation. Provided, of course, the insurance company will come to the rescue if the vehicle is insured. Suppose the vehicle is not insured over there, then the owner should have to pay from his pocket. So that was the another case. Okay. So these are the thing, and see, these are the few only. I gave only 6. But if you happen to see in some other books which I wrote, see, this is the book which I wrote that is called Understanding Law, where I made the distinctions between the tort and a crime. So this book which I written in Tanzania, where I was working there. So what is the difference between the tort and crime? There I made, tort is an injury to the individual generally, whereas the crime is an offense against the public. Tort is a civil wrong, and sometimes both civil and criminal wrong, whereas a crime is a violation of the public right and duties. I repeat, tort is a civil wrong, and sometimes both the civil and criminal wrong, whereas crime is a violation of both rights and duties. See, in tort, the victim filed for the damages, but in crime, the prosecution done by and the name of the state. D, the object of the action is recovery of damages, and in crime, the object is to punish the wrongdoer. E, an individual bear the cost in filing the suit, whereas in the crime, police prosecutor or DPP or the state APP state conduct the proceedings and bear the cost. F, intention is essential condition in some cases, but not in all the cases in tort, whereas in the crime, intention is the cause of the offense, that is guilty mind. And G. Damages are unliquidated in tort, whereas in the crime, also unliquidated damages cannot be claimed, but in certain cases like rape, the court suo motu punish the offender both in prison and fine. The fine is given to the victim of rape. It is the later trend in the criminal jurisprudence. Another in tort is based on the preponderance of the proof. Just before I told you, the crime is beyond the reasonable doubt, and there is no stigma in the tort, but the crime there is a stigma. And mens rea is not counted in law of tort, but in crime it is primary criteria. So how many I counted? A, B, C, D, E, F, G, H, I, J. Total, it is 10. I made the 10 in my book, which is Understanding of the Law, Question and Answer series. So, just I will show you my the core page, of course later, because I have to go down, then I have to make it out. So then you will see again what is the difference between the tort and a breach of a contract. So let us see that what I compiled. Tort and a breach of a contract distinction. Number one, in the case of tort, the duty is fixed by the law or by the operation of the law or by the common law or customary law or any law. Whereas in the case of the contract, a duty is fixed by the parties involved. Those who are parties, they will fix the duties, terms and conditions. Anyone read the second point? Unmute and read second point. Anyone?
In case of a tort, the duty is towards everyone in the society, whereas in the case of a contract, the duty is towards specific individuals only.
When the specific individual will say no, we will say in personam. But you will say everyone means we can say right in rem. In case of tort, the duty is towards everyone, means to against the whole world. There is that right in rem, that is everyone in the society. Whereas in the case of the contract, the duty towards a specific individual only means the duty towards the in personam, in particular person, those who are party to the
Duty.
contract. 3. Motive is often taken into account in the case of tort. Our intention will be often taken into account in the tort. Where in the case of the contract, motive is irrelevant. There is no question of motive. There is no question of intention will be relevant over there. But when it comes to the damages, in the case of the tort, are different under different circumstances. Whereas in the case of the contract, the damages are in the form of compensation for the loss suffered in peculiar form. When you count in the tort, there are nominal damages, contemptuous damages, exemplary damages, anticipatory damages, aggravated damages, general damages, special damages. These are all comes under tort. But when you come to the contract, only damages are only compensatory in nature. Only in certain cases, the special damages are awarded. I don't know whether you will study in the case law of contract, there is one case law is there where the special damages awarded. That means it should be special conditions should be provided over there. Then only the special damages are awarded. If there are no conditions put it over there, then the special damages will not be awarded. Do you know the name of the case law? It's a very remarkable and landmark case law. Yes, in contract. If you know it, you tell me. If you don't know, you say pass on.
Sir.
First answer.
I will give the facts of the case law. Can you give the name of the case law? With the facts like that. So if the mill owner, the shaft is broken and he has given to the carrier to repair the shaft and take it to a different place. But it is instead of making to return within 1 week, it took the longer time. By the time the mill is closed, number one. Number two, whatever the losses which is incurred over there, that also going to be paid. So they said, no, because you did not inform that because of this shaft is not there, your mill will be closed. But we thought that this shaft is given, that means you have the spare shaft which you are running the mill. So the special damages are not awarded over there unless until it is clearly mentioned in the contract. Yes, can you tell me the name of the case law?
Pass on, sir.
Hadley versus Bugs and Dale. It's the case law is Hadley versus Bugs and Dale. That is a very remarkable case in the law of tort contract that will come across. Okay, in the fifth case, in the case of the tort, intention is taken into consideration in some cases. Yes, sometimes motive also then. Sir, what is the difference in the motive and intention, sir?
Both are synonyms.
No. It looks like synonyms, but not. Intention is different and motive is different. Okay, I will give you in there. The ulterior intention is motive. I repeat, the ulterior intention is motive. So taken into consideration in some cases where in the case of the breach of contract, intention is irrelevant. What is the intention they do is irrelevant. But in certain cases, I tell you, the intention is relevant, like the Hollywood Silver Fox versus Emmett, Christie versus Davy. These are the case laws. Of course, later part I will tell you where the intention is relevant in the law of tort. There are 5 cases where the intention is relevant, I can say. Okay, example, a father who employs a surgeon for the treatment of his minor son, and his son is injured by the surgeon's carelessness, and here the father can sue the surgeon for the breach of a contract, and there is no contract between the minor son and the surgeon, and the minor can sue the surgeon for the carelessness act which amounts to negligence in tort. It can also put charges on the surgeon, but they can't sue for the breach of a contract. So when there is a contract between the father and the surgeon, medical officer, for the surgery of the son, if son got injured because of the medical negligence, son can bring an action against the doctor under the negligence, even though there is no contract between the son and doctor. Of course, son cannot make the contract if it is a minor. But the father can make the sue for the breach of a contract. So both can sue them. So that was the distinction that we will see it. Let us see that what I wrote, the additional things in my book. So tort and breach of contract. In tort, a duty arises from through the operation of law and it is imposed against the whole world. That is the right in rem. Whereas in the contract, the duty arises from an agreement of the particular persons. Hence, it is a right in personam. B. Limitation period of 3 years. Of course, this is given in the first schedule of the part law of limitation 1971. This is, of course, our is a little difference would be there, I believe. I don't know the law of limitation 71 because it is a Tanzanian law, and hence I put that thing. But here also, generally, the tort law, where we can say the 3 years, but when you say the contract, generally it is a 6 years because general principles and limitations are the common, both the common law countries. Because Tanzania also a common law country, India also a common law country. The same case law we can cite in Tanzania also, like Donegal versus Stevenson, in addition to the local case laws. Is it clear?
Yes, sir.
Number C, in awarding damages, forcibility test is applied, whereas in contract, the laws which arises naturally, which are within the reasonable contemplation of the parties, there is no forcibility test would be applied over there in the contract. But in the case of the tort, yes, forcibility. I told you one stanza. What's on the? I give a stanza like that. Reasonable forcibility does not mean remote possibility. Discuss with the decided cases. I repeat, reasonable forcibility does not mean remote possibility. Discuss with the decided cases. If it is given like that, at least you have to cite 5 cases regarding the reasonable forcibility. I'm sure that if the 15 marks are there, you are going to get the 15 marks. If the 20 marks are there, you are going to get the 20 marks. Because no case law, no case
No
law,
tort law. No tort law.
I already told you in the earlier classes only, and I have shown you also no case law, no tort law. Again, I will show you this thing. Read.
Tort law is nothing but product of case laws. Tort law is multiplication of case laws. No case laws, no tort law.
Yes, I already told you no tort law, no case law, no tort law. Okay. Next, in awarding damages, yes, forcibility test would be there in that tort. D, the tort for the unliquidated damages. I already told you what is unliquidated damage. Can I will test your IQ or can I test your memory? What is unliquidated damages? Anyone? Or you can say pass on. Or you can say pass on. Anyone? Or you can say pass on. Are you hearing me? Are you hearing me? Are you hearing me? There is some problem, I believe. Are you hearing me? Anyone? Andalu, can you unmute and give me the answer? Deepa, Himaja, Rashmi, Joshua, unmute and give me the answer. Are you hearing me? Problem has occurred. Yeah, there is a little problem occurred over there. That's why I could not hear your voice.
Sir, now it is clear, sir, for me.
Because when I saw why you are not giving the reply, when I asked at least, are you hearing me? Are you hearing me? Then I found my Wi-Fi disconnected automatically. But it never happened like that. But immediately I saw, I connected it. But I don't know whether the recording will be continued or not. But anyway, how far that
Okay,
will go, that will be given to you. If not, just you hear me. Okay. Because sometimes it will not jump because I do have my inverter also in my house. So anyway, it doesn't matter because something which is not in our hand. Okay. So now let us see that limitation period is 3 years generally, and for the contract, it is 6 years should be there. In avoiding damages, forcibility test would be applied, but in the contract, there is no forcibility test. And I asked what is the meant by unliquidated damages? Anyone can unmute and give me the reply. If you don't know it, you say pass on.
Pass on, sir.
Unliquidated damages means which is not predetermined.
Don't have fixed amount.
Which is not predetermined. It will be calculated only later. That is called unliquidated damages. And whereas contract liquidated damages means if it is the breach of a contract will be there, okay, that much fine will be imposed over there. That is determined by the two parties. That's called, we say, liquidated damages. In tort, the other party, whoever may be there, he or she may be, who are unknown till the wrong is committed. Because unless until the accident takes place, we don't know who is the other party. So, in the same manner, in the contract, parties are known to each other, but a stranger to the contract cannot be sued. Are you following me? Say yes.
Yes, sir.
Yes, sir.
What is the remarkable case law? A stranger to the contract cannot be sued in the law of contract. I already told in my earlier classes. Dunlop Pneumatic Tire Company Limited, Selfridge Company. That is a remarkable case law where you say a stranger to the contract cannot be sued. Okay, next, F. In tort, the punitive damages are avoided, but punitive damages are not available for the breach of contract. Punitive damages means exemplary damages. Exemplary damages are awarded, anticipatory damages are awarded in the tort, but no such damages only in the breach of a contract. Either a general damages or a special damages or compensatory damages. Okay, next, stranger to the contract cannot sue. Yes, I told you, Dunlop Pneumatic Tires Company versus Selfridge Company, the remarkable case law. But in tort, there is no reason why the same set of facts given rise one person right of action in tort, though met in a contract. The stranger can be sued under the tort negligence. In the negligence, a stranger can also be sued. That the one of the very famous case law is Class-04-02-2022 versus East India Hotel Limited. In other words, we can say German pilot case law. It is a German pilot case law. There is no privity in tort, as there is no privity in a contract in general. The privity in there in contract generally, but there is no privity in the tort. So the beautiful example is there, Class-04-02-2022 versus East India Hotels Limited. It's a German pilot. And the German plane, what is the German plane is called? What is the name of the German?
Lufthansa. Lufthansa.
Lufthansa, I appreciate. It's a Lufthansa, a German pilot. So they used to stay in the East India Company and East India Hotel Limited. And when the time comes now, I will give the explanation. Because this case law, I can use it like 3 to 4 places. Like actio personality maritem cum persona. The personal action dies with the person. There I also use this case law. And this case law, remote possibility also I use this case law. Reasonable foreseeability does not mean the remote possibility. There also I can use this case law. This case law can be also used. A person who is not in a contract, but in the instance one can file a case. The kith and kin can file a case even though the person died. So this is a very important case law. You could remember the Class meter by chart versus East India Hotel Limited. In other words, German pilot case law or Lufthansa case law. H. In tort, there is no agreement in both the parties, and the law imposes the duty to act within caution when it is possible to injure other or cause injury to another person or property. But in contract, where the both parties agree on the same things, there is one terminology would be there: identity of mind. Can you tell me what is the Latin terminology? Identity of mind. Because I say that I am going to sell my house. He is having the 2 houses. Suppose one house name is a big house, another name is a small house. But he did not say, but I am going to sell the house. But there it is not determined whether he is going to sell the big house or a small house. Then another party agreed over there. But at the time, he thought that the big house he will sell. But the seller says, no, I would like to sell the small house. So, identity of the mind is not there. What is the Latin terminology which can be used in the contract? Anyone? If you don't know, just say pass on.
Pass on, sir.
Consensus ad idem. Consensus ad idem. That is the terminology. Because what they said, they should have the same consensus for the same thing, ad idem. That is the Latin terminology of law of contract that you use it. Next is, in tort, the time limitation starts from the occurrence of the damage. When the damage occurred over there from that day, the time will start. But in the contract, time of the limitation begins from the breach. From the breach, when it's caused, the limitation time begins from there. In the last point, in tort, mental element is sometimes taken into consideration, but in the breach of contract, mental element for the breach of is immaterial. So, mental element means like a motive or intention will be taken into consideration sometimes in the tort, but there is no such a mental element will be taken into consideration in the breach. In the contract is the material, we can say. So, if you happen to see the syllabus, I don't know whether you have the syllabus with you or not. Do you have the syllabus with you? Yes?
Yes, sir.
If you happen to see the syllabus they wrote,
Yes, sir.
distinguished from the crime and breach of a contract. But I do have another syllabus, but there it say it is a distinction for the quasi-contract and the distinction between the trust also. But I don't know whether you want to read the breach of trust as well as the quasi-contract. But as per the syllabus, you get verified from by asking your class teacher or to your principal, which is the syllabus. Because in another syllabus I found, it is a distinction between the crime and a breach of contract, breach of trust, and quasi-contracts. So, of course, there are not that much distinction would be there, very little distinction, because the trust is nothing but the contract only, in one way, and a quasi-contract is the partially contract only. But when you say the general principle of liability in tort, there comes many things. General principle of liability in tort. But anyway, in a short look, because still we do have some time with us, let us see that what is the distinction we can see in the breach of trust. So let us see, torts and the breach of trust is distinguished. In case of a tort, a compensation in the form of unliquidated damages. Yes, obvious factor. Whereas in the case of the breach of trust, the compensation is the form of a liquidated damage. The same thing which will there in the contract. Are you following me?
Yes, sir.
Yes,
Yeah.
sir.
So the law of tort is originated is a part of common law. Law of tort is originated from the common law, whereas the breach of trust is could be redressed in the court of chancery. It is originated from the redress from the court of chancery. Means it is a breach of trust. It's come from the chancery division. So number 3, law of trust is regarded as a division of the law of property. It is a law of property division. Which one is trustees? Whereas the law of tort is not regarded as the division of the law of property. So liquidated damages and liquidated damages, I made it very much clear here. Both of these damages certify the plaintiff not to be compensated. Liquidated damages are one hand, either amount of the compensation fixed, while on the other hand, unliquidated damages have no prior fixed amount. They change with the intensity of the offense committed by the defendant. The extent of the amount to be compensated in the case of the liquidated damage is predetermined, whereas in the case of the unliquidated damage, in order to get the maximum compensation, the plaintiff to prove the extent of the damage he has suffered. So some general conditions on tort. There would be an act and omission. Again, we will say the voluntary and involuntary acts. Then malice, we will have the wrongful act in which the malice is essential, defamation, malicious prosecution, willful and malicious. Let us see one after another to the extent we can cover it in the today class. But I don't think that I can cover in the today class regarding the anatomy of the law of tort goes with the general principle of law of tort. So some general conditions on tort is act or omission, as we said it already. And we cited the many cases in act and omission. Is it or not? Is it or not? Say yes.
Yes, sir.
Can
Yes,
you tell
sir.
me one case law, either in act or in omission? Either in act or in omission? One case law?
No
Yes,
idea, sir.
Yes. Himaj Rashmi, repeat. Sir, yesterday
No idea, sir.
I told so many cases in the act or omission. It is a one. Clock Tower case law I told you. Chandni Chowk I told you. Red Fort I told you. And maintenance of the, I told you, Municipal Corporation of Delhi versus Saubhagavanti. That is the omission. And I also dictated the case law and I revealed the case law. Belladonna, which is look like cherries. And a boy plucked down in a public garden. And the garden doesn't have the fencing. And they did not keep the caution board. And the boy ate and died. This is the omission of a duty. What is the name of the case law? Sir, ఈ పేరు గుర్తుపెట్టుకోవాలా సార్ నేమ్ ఆఫ్ ది కేస్ లా
Gaslow Corporation versus Stylo.
Glasgow Corporation versus Taylor. That is the case law.
Yes, sir.
No case law, no tort law. You have to keep it in memory. So the best way to remember is read and read, or read, recite and review. 3 R's. Read, recite and review. That is only the best way to remember the things. So now voluntary and involuntary acts. So voluntary acts, that is one maxim is there, voluntary not fitting area. Suppose boxing is there. Boxing lo ఏమవుతుందండి? కన్ను మీద ఎత్తే పని చేస్తే ఏమవుతుందండి? ఇది
కన్ను పోతుంది సార్.
కన్ను పోతుంది కదా, వాస్తుంది మొత్తం, కన్నే కనబడదు. ఇది అంతా వాసిపోతుంది, కమిలిపోతుంది. ఇంగ్లీష్లో చెప్పండి, కమిలిపోతుంది అని చెప్పండి. If you don't know, say, pass on. I will give the answer.
Injured, sir.
పాస్ ఆన్ సార్.
కమిలిపోవడంకు ఇంజూర్డ్కి డిఫరెన్స్ ఉన్నది. The eye socket is bruised అంటారు దాన్ని. ఏమనాలా? Bruised. 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 మనం వేలు పెట్టామనుకోండి ఎందులో డోర్ సందులా ఏమవుతుంది? మన నెయిల్ కాడ ఏమవుతుంది?
It
కమిలిపోతుంది,
gets bruised.
నల్లగా అయిపోతుంది.
Yes, sir.
దాన్ని
బ్లడ్ క్లాట్ అయింది.
కమిలిపోవడం అంటారంటే బ్రూయిజ్డ్ అంటారు దాన్ని. సో when it is bruised over there, then can he bring an action against the opponent?
We cannot.
Yes, sir.
He cannot bring an action against the opponent because he voluntarily agreed to undergo the injury. కానీ కడుపులో మాత్రం కుట్టద్దు. ఆర్ యు ఫాలోయింగ్ మీ?
Yes, sir.
Yes, sir.
Above the belt, below the head, heart, we should not strike him. So certain places are there you are not supposed to punch. It is against the norms. So if a person did it, means he will be held liable. So voluntary not fit injury also we will have a chapter. When you voluntarily undergone the injury over there, at the time you are not going to get it. We have the beautiful example, case law sunai, K versus shop, if I have not been mistaken. Yeah, that is a case law is there. Suppose fire brigade అంటే తెలుసా అండి? ఫైర్ బ్రిగేడ్ చెప్పండి.
Yes, sir.
Fire,
Fire department, sir.
fire
ఫైర్
department.
డిపార్ట్మెంట్ ఏం చేస్తారంటే ఫైర్ బ్రిగేడ్ అంటారు. వెనెవర్ ద విలేజ్ hut is burnt over there, the fire brigade, till it comes to the inferno place or a burning place, up to that extent the neighbors can go and take away the material, even pull down the roof. You are speaking each other. Mute it. I am getting the sound. You are speaking. Anyone can speak now, I will get the sound immediately. Okay, when the fire brigade, till it reaches to the spot, the neighboring people go and remove the thatched houses, remove the any things which are going to be burnt, and up to that extent they are not called the trespassers. But once the fire brigade entered into the premises, if you entered it, the neighbor, you will call it trespasser. Is it clear?
Yes.
Yes, sir.
Don't worry. In the further classes we will read it. Malice means the bad intention. So malice in fact means, malice in fact is there, malice in law is there. Malice is an implied malice or express malice. When a person has a right to do an act, it is not possible to make an exercise of such a right actionable, whether malice is there or not there. And sometimes we can count it, sometimes we cannot count it. So that also malicious motive is there, per se does not amount to injury or legal wrong. What is the malice he is having, bad intention he is having over there? So sometimes it is irrelevant, sometimes it is not relevant, we can count it. So when you come to the matter of the malice is an essential element where defamation is there. Sir, why do you call another woman as a prostitute, sir? What is your intention? What do you want to say? If you don't know her name, could you call her as a prostitute? I told you what is the
No, sir.
prostitute. Professor Hussain will not say prostitute. I told you already. Sir, ఎవరికి చెప్పినో మాట్లాడుతున్నారు సార్ అంటారు. No, generally I told you. Harlot, HERLOT, harlot. Oh, ఇదేం సార్ కొత్త పదాలు వాడతాను. Because if you lose my class, you lose many things. So harlot. So you cannot supposed to call harlot. Enduku? Every village people know that she is a harlot. But still, you are not supposed to call her with the harlot. Why? Because she is having the name. You call with her name. So what is your intention to call harlot? Tell me. Means some malice will be there in you. Hence you want to call her. So in the defamation, malice is there. In the malicious prosecution also. Saru, దారిని కూడా పేరు ఇచ్చిండు సార్ దాంట్లో. పాపం వాడు అక్కడ కానేగాడు, వాడు దారిలో పోతాడు అంతే. బట్ he saw somebody saw his name and he put his name also there. There is a malicious prosecution. The bad intention is there. Willful and malicious damage to the property. There is a malicious intention is there. So slander of title or maintenance. Slander of title. సార్ తిట్టింది అనుకోండి సార్, తిట్టితే ఏమన్నా అయిందా అండి? ఏం కాలేదు. నో, ఇట్ ఈస్ అన్ ఇంజురీ. యాక్షనబుల్ పర్ సే స్లాండర్. డిఫమేషన్ చెప్పేటప్పుడు చెప్తాను నేను. ఐ విల్ టెల్ యూ. స్లాండర్ ఈజ్ ఏ ఓరల్ స్టేట్మెంట్. లిబల్ ఈజ్ ఎ రిటన్ స్టేట్మెంట్. ఈవెన్ ఓరల్ స్టేట్మెంట్ ఆల్సో ఏ డిఫమేషన్. Are you following me? Say yes.
Yes, sir.
Yes, sir.
Yes, sir.
So intention, motive, negligence, recklessness, these are all comes over there. Motive and the ulterior intention is motive annani. If a good motive or bad motive, doesn't matter. If the injury is there, it's enough. Negligence is the part is there or not. Or recklessness is there or not. If the suppose a clock tower fell down, that means it is a recklessness or negligence on the part of the Municipal Corporation of Delhi. That is also res ipsa equita. The thing speaks itself. Then fell down means fell down. That means that you are negligent, even though you are taking the repair from time to time. So that is also a one point where we can make it out. And a want of knowledge of the illegality, omission, excuse, all these things that we will study under it, intention, motive, and other things. But the tomorrow class, malfeasance, misfeasance, non-feasance theory. I repeat, malfeasance, misfeasance, non-feasance, you read it. Again, we will read the general principle of liability in tort. General principles under it, we will come across principle of tort. Demnem sine injuria is there, we already studied. And then this is not out there. Injuria sine demnem, we already studied. Again, principle of vicarious liability, we will see it. These are general principle of tort liability. And we go voluntary not fit injury, just before I told you the boxing. And then we can say the strict liability and absurd liability also comes from the general liability in tort. We will touch it because we do have separate chapters for this. Strict liability, absurd liability, we have separate chapters. And we read in depth. Voluntary not fit injury, we have a separate chapter. We read in depth. Principle of vicarious liability, we have a separate chapter. We deal in depth. Of course, injuria sine demno and gemne seno injuria, we already read it. So we need not worry about that one. And who are the parties to the contract also will read a separate chapter that is called general defenses. So tomorrow when you are coming, just have a glance of it so that we will try to complete the first chapter, first unit. Oh, మాట్లాడతాండ్రు మీరు మ్యూట్ పెట్టుకొని మాట్లాడద్దు మీరు మాట్లాడేదంతా నాకు వినబడుతుంది whatever you speak that I could hear you.
Thank you, sir.
Yes, mute it when you want to speak. At the time that you have to unmute and then you speak it. That's only the thing. Otherwise, whatever you speak in the personal talk now, I could hear. So tomorrow that you can read the general principle of liability in tort, but also read the misfeasance, malfeasance and non-feasance. There is very famous case law is there, 6 Carpenters case law. Dani pere, but it is having its name, but it is famous by the 6 Carpenters case law. We do have only the few minutes in our hand. It's our tradition that we will make every program start with the national anthem, Jana Gana Mana.
Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat Maratha Dravida Utkal Vanga Vindhya Himachal Yamuna Ganga
सारे जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।